At this point, we will begin the program. We're going to call on Dan and Steve. They're going to tag team the topic of apartment alterations. What is needed for all involved parties. Dan, of course, is with Finger and Finger, which serves as chief counsel to the CCAC and the BRI. Steve Lasser is with the Lasser Law Group, a member of the BRI. Steve has offices in Manhattan and in White Plains. So at this point, we'll turn the program over to Dan and Steve, and we'll go from there. It's all yours, guys.
Thanks. Good evening, everyone. Thank you, Jeff, for the introduction. We're going to talk tonight about apartment alterations. We're going to tag team a little bit. I'm going to go through some slides, and Steve is going to jump in and fill in. And I think we're primarily going to go through we're going to use the normal alteration framework. And we both use, I think, basically the same form for an alteration agreement. That's something that basically every co-op and condo should have, and I'm going to get into that a little more in a minute. But it's important. It provides all the framework for the project, the guidelines, what those responsibilities are, and in other words, everything that you need to know and be aware of. So, starting, the first thing to talk about is the parties that are involved. In just a couple of seconds on this, obviously the board of managers, board of directors, depending on if you're co-op and condo. The managing agent. The managing agent does everything for you, as you know, on a day-to-day basis. And there's no reason this should be any different. They need to process the alteration agreement. They want them aware that this is going on, that the alteration and the project is going on, so they can keep track of it. There's a lot for them to keep track of and to be aware of for a variety of reasons that we'll get into a little bit. The unit owner and shareholder, and not only the unit owner and shareholder that's doing the work, but you also have to be aware of the neighboring unit owners and shareholders. They may be affected. Everybody might be affected, but specifically the neighbors, depending on the scope of the work and project, they may be affected.
Good evening, everyone. Steve Lasser, Law Group. So, I know a lot of you were probably late last night and you're tired. This isn't the most exciting topic on planning, but it does affect everyone who lives in a co-op or a condo. So, I'm just curious, sort of make this a little bit interactive. What are some issues people here have had with people doing renovations in their building? You know, maybe story to share or insight, something bad that happened, maybe? Yes?
Typically that they don't tell you they're going to do it.
Okay. And then what was, you didn't know, so it was a surprise, but did it affect you adversely in some other way?
There was destruction of the building. One time we had our heating system disrupted in the building. They don't tell you, so you don't know what's going on, so you don't know how to manage it.
Right. So this woman indicated that there was a situation where there was an issue with the heating from someone doing a renovation. So I wrote down just a few things. Dan and I are going to talk about the alteration agreement, which is sort of the cornerstone of protecting your building. But some of the things that are covered by the alteration are like the hours of work. I think it's good to know what time someone's going to start construction, what time someone's going to finish construction, so you can have sort of an expectation. Are they permitted to work on the weekends? What if there is a flood? I had a situation where a contractor had cut, doing some work, plumbing work in an apartment, and they didn't properly cap a line where they were doing the plumbing roughing, and they turned the water back on, and it cascaded down, for 5 floors. Now, luckily in that situation, there was an alteration agreement in place, and there was insurance in place, so everyone pretty much got made whole. But that's things like that happen. So it's really important that you sort of have proper safeguards in place, and you should definitely examine this issue with your management and make sure that it's being done. Some other things that came to mind for me were noise, are people using a jackhammer, dust, right, could be in the hallways, you have contractors.
I'm going to get to all that, so let me...
No, just sort of throwing out some issues they see there. And then there's also the duration of the actual project. So Dan's going to talk about the actual alteration agreement. The other thing I want to say is that you should look at your governing documents. And by the way, there's an outline here that I prepared, so a lot of what I'm saying is coming straight out of the outline. And it sort of mirrors what Dan has prepared, I believe. So in a co-op, anyone here live in a co-op? Board members, residents. Right, so in a co-op, the governing document is your proprietary lease predominantly. And there's typical language there that says that a lessee shall not allow first obtain the consent of the lessor, which would in this case be the board, make any alteration in the apartment. So it's in your proprietary lease, and sort of the alteration agreement, which Dan's going to talk about, is sort of a document that works in conjunction with that, but the authority comes out of your proprietary lease. And then the other thing, in a condominium, typical language says that no owner will make any alteration or addition without the prior written consent of the board of managers. And typically, there's a 30-day time period for the board to respond to a request to make an alteration or it's deemed approved. So one thing sort of flagged as a board member in a condo is that if you receive an application for an alteration, you need to act on it within a certain period of time where it's deemed approved. In my building, I live in a co-op. We basically let the management company handle all that, and the board really doesn't get involved in the operations. We need to make sure that the management company has a process in place and that they follow it in a timely manner, or it could be deemed approved if they fail to act.
Okay, so continuing just to get, so we all have an idea of who's involved. Like I said, you have to be concerned with the neighboring shareholders. You definitely want to know who the contractors are. You want to make sure that it's a licensed and insured contractor. And you want the contractor to sign on the alteration agreement as well. You want them to be aware of what the rules are, the guidelines, what you're requiring. And I'm not going to talk too much about insurance because Jason will handle that end of the conversation. But the insurance companies are parties. And the unnamed, unlisted people are your attorneys. If you have any questions when you get an alteration agreement or somebody's asking you about an alteration, obviously talk to your managing agent, talk to your insurance company if you have to, but talk to your attorneys. Ask them. If you don't have an alteration agreement, you should. So the role of the board is, I always mention things even if I think they go without saying, or I like to say them anyway to make sure people are aware. So the role of the board, you want to make sure that you're protecting the common elements and the other unit owners or shareholders. So, and that's at least part of what the alteration agreement does. You want to make sure the bylaws are followed and rules and regulations. I know that everybody has them and given them whether they got it before they bought or sometimes, as you amend rules and regulations, you give them to people. Again, but in this type of situation, you want to make very certain that they're aware of whatever rules you have as far as doing work into their unit. You want to make sure that they're aware. They can't touch the common elements. That Stephen mentioned, that they know what the allowed work hours are. You don't want them coming in and working at 10 p.m. At night. You don't want them starting maybe at 6 a.m. They may want to start really early in the morning, but that can be disturbing to people. You might not want to allow them to work on weekends. So there's all those issues. Noise. Is there going to be too much noise? You want to make sure they adequately protect the common areas, the common elements. So there's all those things, and you might have many of those rules in your rules and regulations. Even if you have it, even if you handed it out, this is a good opportunity just to make sure again that they're aware of them, so that there's no excuses if they didn't know. Okay. I kind of touched on all this, the general requirements that the alteration agreement usually has, and that you would want anyway, are the contractor has to be licensed, they have to be insured, the unit owner or shareholder and the contractor should all sign on the alteration agreement, and you also want a time frame on the work. You might not want somebody doing a project that's going to take 6 months or 8 months. You want to know how long the project's go on for. You want to make sure that it's not too much of an inconvenience to the other shareholders, unit owners. Those are all valid questions that you want to ask, and you're going to want to have, you may, depending on the type of work, the scope of work, you may want to have your own architect or engineer review their plans, so that would be part of what would be submitted, along with the alteration agreement. There's a number of things like that that get submitted. Yeah, all right, so then the submissions, things that they submit with the alteration agreement. You want, like I said, the plans, drawings, specifications, so, if it's something little, you might not be worried about that. But if they're, if they're moving a wall or moving walls, or they're touching plumbing and moving electrical and all those kind of things, you want to see those things. Anything that could have an effect on the common elements. So you have a situation like somebody mentioned about your heat going down, or whatever. You might, you want to have your engineer, your person, review it and make sure that it's all okay. And again, the timeline, the alteration agreement, and then there's certain fees. You want to have, again, depending on the size, depending on what they're doing, you may want to have a security deposit so that if something happens, you have at least something there, to cover yourself, to cover your costs. And how much that's going to be, that's up to your board. That's something you kind of have to consider on a case-by-case basis, and it will depend on, among other things, the size of the project they're doing. If it's a small project and there's not much risk of damage, then maybe you don't have to worry too much. And you also may want to have some deposit paid with you in advance if it's the situation where you're going to have to pay your architect or engineer or your contractors to review the plans or review the project. They're going to have to be paid. So you're going to want to have the applicant put the shareholder put down some money or give you some money in advance to be able to pay that. You should be able to get some idea of what those fees are going to be in advance. I'm sure your architect, engineer, plumber, contractor, whatever, they can give you an idea of what it's going to cost them to review a project. And you want to have something like that in advance so that they can be paid. So you don't have a situation where they did the work and now the unit owner's not paying, and then you have to go and pay.
Just another point that I might cover later is that depending, you have to evaluate each project because it can be faster when someone's sort of gut rehabbing their apartment versus changing scouts or something. It varies greatly. I think on some level there are what I put in my house. Something like that, then you probably don't need the building's design professional, architect, or engineer to review the plans. However, if they are doing like the gut rehab, you don't necessarily want to trust their architect, not to disparage architects, but they're going to do everything correctly, or their contractor. But you want to have your own eyes and ears, and you don't necessarily want to put that responsibility fully on the manager. So it's a good idea to take a deposit if you think it's going to be a large project that's going to require you to pay your design professional. You want to make sure that the security deposit is adequate to cover that, so that you're not chasing the unit owner or shareholder for money once the project starts. That hey, it's going to cost another $3,000 for our design professional to review these plans, or another $1,000, and they say, well, I already paid you. I'm not putting any more money into this. So that's just something to keep in mind. Have an idea what the scope of the project is. Make sure you have adequate funding to the ability to go that line.
Right, and that's something that you can adjust along the way too. You have them give the alteration agreement, or you have them give the plans, the general proposal, and I actually didn't put that in there, but also you would want a copy of the contract between them and their contractor. You'll have an idea if they're, like Stephen said, if they're doing gut rehab and they're paying their contractor, $50,000 or whatever, that's substantial. Then you have an idea that you're going to need your engineer and your architect, and you can call them and give them the general 2-minute version, and they'll tell you about how much it's going to cost. But then if you start spending down, if that guy starts doing, the person starts doing the work, and, you know, it looks like it's going to cost more, then you get more before they do more work, or else you stop it. You know, before, you know, they need your consent, they need your approval and your architect or engineer's approval before they finish their work, before they can start their work, before they finish the review. Okay, so just the general kind of parts of the alteration agreement, it's, you know, for the project, the contract, everybody has to sign. You know, the board has to sign, the contractor has to sign, the owner and shareholder has to sign. It has in there all the rights and responsibilities for before the project, during the project, and after the project for everybody. And, you know, what your rights are as a board, what the obligations of the shareholder are, and you want the contractor on there also, so they, you know, so they're aware of the insurance requirements and everything, you know, the rules, the work rules, you want them aware of when they can work, when they can't work, all those little details, you want them aware. So you want them to sign on it, so that way there's no issues or questions about whether they were aware of those things. It also contains generally the preconditions to the work, insurance requirements, performance requirements, some of this I already said, and completion requirements and stuff for after completion I'll get into.
That sounds like a legal document.
Sorry?
This sounds, this alteration.
It is a legal document. It's basically a contract between.
Because I've never seen one done in our building.
A lot of buildings don't, you know what, I always recommend it to, you know, to all my boards. There are a lot of boards that don't want to do it. Some of them complain, well, then people aren't, you know, we only want something really short because then people aren't going to sign it, or we only want to require a hold harmless and their insurance because we don't think people are going to do it otherwise. I mean, my response is, if somebody doesn't want to sign it, doesn't want to tell you about the, you know, the project, they're not going to tell you about it, and they're just going to do it, and you're going to be in the same situation anyway. I am more of an optimist. I like to believe that most people, if this is the policy and you make them aware of it, they'll sign it. But it is a legal document. You know, it covers all the responsibilities, and it's something that you want to be able to enforce.
Well, we're finding they're going to the property manager with a minimal amount of work. They get in and they start getting gross like that.
Well, that's the whole point of the alteration agreement.
Can you speak up a little bit?
Sure. One major point of the alteration agreement is that it requires the person who's doing the alteration or renovation to submit in advance all of the work that they plan to do, proposed plans, and it also gives the board the right through its managing agent or through its design professional, the architect or engineer, to go in during the course of the renovation and not even giving advance notice, just go in and see what's going on. And that's sort of critical, because I think a lot of people, you know, for better or for worse, they start off with a project that's going to be X, and it turns out to be X plus plus over time, for whatever reason, right? Construction just doesn't always seem to go the way it's scheduled, or it just, you know, grows in scope. So, you know, I think it's important that you have that document in place up front, and then if the person isn't completely honest about what they intend to do, you'll eventually find out, hopefully, before it's too late.
And usually I like to have as a guideline, you know, we talked about something little like painting or changing a sconce, you know, that's one thing. But anytime you're moving walls, doing what I call real construction, you know, touching pipes, touching, you know, electrical, anything like that, you know, where you need real license protection. We're not talking about handyman work. You know, anytime you need like some kind of licensed insurance contract or professional, you want an alteration agreement. And then if you have it, then it doesn't matter if the project grows. You're protected. They have to get, if they're changing their plans, they got to get approval. They got to show you the plans.
And just as an aside, the agreement that I think Dan and I, you know, have a template based off. There's a standard form. It's very comprehensive. It's probably like 6 or 7 pages most of it is, but it's sort of idiot-proof, and to the extent that it's been prepared, it's sort of time tested. There's very few things that are left out, and you know, initially someone might get it and say, you know, this is ridiculous, and I think you know, view it on a case-by-case basis. The artist doing painting, it is probably overkill, but if they're doing plumbing work, doing electrical work, it's not overkill. If they're not willing to sign it, then you probably don't want them doing the work in the building.
So, what is the cost factor to have this type of agreement done?
Wow, it
And are you
depends on
not
who
in
you're.
effect acting as construction managers? What is your background? You're an attorney?
I'm an attorney, a real estate and construction attorney. So, to answer your question, I think the added cost factor, whoever is general counsel to your building can give you a template, okay? Like a standard form of agreement. So there really shouldn't be any additional legal costs. With respect to the managing the project, I think it's not your responsibility, it's not the board's responsibility, it's the property manager's responsibility to manage the project. However, if it's a big project, you should periodically, or at least once during the course of the work, have the architect or the building's architect or engineer examine it.
Right, but then there's a distinction that I think is worth mentioning. You're not managing the project. It's not your project. It's the shareholder or unit owner's project.
Right.
You want to inspect it from time to time. You may have, certain issues. You want to go through the plans and everything beforehand, depending on the scope.
So this is
But
specifically for the availability of the board so that they can do these things?
Well, right, this is
But
when
there's
a
nobody
shareholder.
overseeing it, there's nobody, you're not overseeing it, you're
No,
not
you're not
charging
overseeing.
for
When a
it.
shareholder or unit owner comes to you and says, I want to do this project. I know your rules and regulations, and I know I'm supposed to come to you and tell you I need your approval. I want your approval. I'm doing this project. I'm gutting my kitchen. I'm walling off my dining room to make an extra bedroom. Whatever. I'm doing this big project. I'm going to completely renovate my apartment. They come to you and say that. You're not. This is not so that you can manage the project. That's not your role. You don't want to be involved. You want to make sure that your engineer or architect agrees with them that the plans are okay, that they're sound, that they're not going to affect the common elements, the building systems, it's not going to affect the heating system, it's not going to affect somebody else's air conditioning or the wiring or whatever. Different buildings, some
So this is just a resource form to give to the contractor so that the architect or the engineer can follow suit, and who is the...
It's not, it's a resource, it's an agreement. It's like I said, it's a legal agreement between the board, the unit owner, and the contractor, so that everybody knows what their obligations are, what their responsibilities are, what the ramifications if they don't follow it are.
Who's the wizard on it? Who is the one that knows whether they're doing the wrong thing or...
Well, that's why you have in terms of the actual project, that's why you would have...
Overseeing the whole thing, just to make sure everybody's in
That's why you
compliance.
have your architects and engineers, they would go through, if it was that big a project, you wanted to make sure that it was, being done the right way.
So
They
you
would
give
be
this
the ones
to
to
them
do it.
and you say, I want to make
Well,
sure...
you tell them, they
all
look at
of
the plans
these things-
beforehand. They look at the plans ahead of time, and the work's not allowed to start until you've given them the consent and sign off from your architect and engineer. So, all right, anyway, so moving on. Now we've actually talked about a lot of this. But, like I said, you need, and we were just talking about, you need the approval of your professionals, the architect, the engineer, and you, as a board, once you get that approval, you would issue a written letter. You want it in writing, so that way, and that's as much for the benefit of the board as it is for the unit owner or shareholder, so they know going forward, if there's any question that the work was approved, if there's any question about that, they have that letter saying that it was approved. And the same thing for the board. If there's any question about the agreement, any question that, you reviewed it, that you have that written approval, and you gave them their approval, and you told them they could start work or their denial.
And I think we're going to cover this a little bit later on. Another reason why you want proof of the consent is, let's say the unit passes hands 10 years later, and there's an issue about, this person put a built-in cabinet, a bookshelf over, let's say, a radiator or something. The building has to get access to it, and there's a discussion. Well, was this ever approved? Did we approve them to put this cabinet over? And who's responsible for taking the cabinet off and putting it back together? And all that sort of covered by the alteration agreement. So it serves a purpose that way, or in showing that it was approved in advance by the board. It might have been 10 years ago it was actually approved.
One question about that.
Sure.
If it's, so shareholder A, everything was approved, the board approved it, shareholder A, moves out in 7 years. Shareholder B moves in 8 years later, and there are issues behind the kitchen cabinets. We're having a mice issue.
Hold that thought for 1 minute.
Okay.
Okay? We're going to get back, I don't want to get into too much, we're going to get back to that. Okay, so the last thing before I move on, you need they need to get whatever permits they're required. If they're required to get a permit from the municipality, they have to get that, they have your approval. You need to make sure that they give all that to you. And again, that you have the licenses from the contractors and their insurance certificates, their insurance. And generally, the work has to be performed according to the plans, within the work hours, the noise kept to whatever the minimums are. Labor harmony, that's not, not their contractors getting along. You don't want their contractors interfering with your building staff. So when I say labor harmony, that's what I mean. You don't want them in common areas. Some of these projects, they may have to use common areas, so you want to make sure that the common areas are protected. They have to bring stuff in the hallways or up the elevators. You want to make sure that whenever they're going to bring it up the elevators, if you guys pad your elevators, you want to make sure they let you know so you can do that, so they don't ruin your elevators or get the common areas in and the common areas dirty. But that also includes you don't want them touching your common area wiring or your common plumbing. You want to make sure they don't do anything that could affect that. There's the general things about safety and cleanliness, and you want them to stick to a completion date. Okay. I'm going to get back to your question in 1 second. So post-construction, so you go through the work, they get your approval, they start the work, it goes great, they do everything that they're supposed to do, and they think they're at the end of their project, and they come to you and they say, I'm at the end of my project, I want my security deposit. So then you have to go, and you have to make sure that the work is completed, and actually backing up a second, some of these things, some things that are going on during the work, you may need your architect or engineer to supervise and to check on and do inspections if they need, depending on the size of the project. Some of the things, it's the management, noise and that stuff. You don't need your architect to be supervising whether they're too noisy. That is kind of common sense, and they're managing the work hours also. That's kind of managing agent stuff. Cleanliness, that's all managing agent stuff. But it's like the safety and making sure it's being done according to the plans, that's stuff for the architect. So you can kind of figure that out. Okay, so you get through the project, they do it, everything's good, they want their security deposit back. Now you need the architect to tell you that it was completed according to the plans, that everything was done correctly. So they may have to inspect the work. You want to know that their own architect is certifying it as complete also, whoever their own professional is. If there's any corrections, they have to make the corrections. If there was any damages to any of the common areas, whether it's hallways, pipes, electrical, whatever, they have to fix that too.
I would say that the other thing with respect to that is that similar means that the standard form agreement that most attorneys use also says that the owner is responsible if they're putting in some kind of new fixture. Someone has some fancy hot tub or something, or some kind of special shower or something like that, that maybe depending on your building governing documents, it might normally be the building's responsibility to repair. It sort of shifts that responsibility over time. If they want to have this special thing there that requires extra work, then if it breaks down, then you're not responsible for fixing their custom fixtures going forward. So it sort of addresses that issue as well. And then just another sort of tidbits I'm just going to sprinkle in here, and I don't have questions. Another thing, if you have an older building, and I'm not just throwing this out there, I'm not trying to work, but sometimes in an older building, if you're particularly in a co-op, if the board has sort of has the right to approve the alteration, they might say, well, we're going to, sometimes it says subject to the terms and conditions the board agrees upon that are reasonable. That might, if you're an older building, it might be an opportunity to go, branch lines running from the garage, someone's redoing their bathroom, have them replace the lines that go all the way back to the riser, not just the fixture and the bathtub. Another rule I commonly see is that buildings will prohibit wet over dry. I know this sounds maybe a new concept, something we can do, but sometimes people will buy apartments and they'll decide to put their new master bathroom over someone else's bedroom, which is, a lot of buildings will prohibit that, so they'll put it in the alteration agreement, wet over dry. There's a lot of ideas out there that are, they're not sort of unique. They've been sort of time tested. If you don't have, someone advising you on some good ideas, just sort of construction practices, which are, incorporated in a typical alteration agreement, you might be missing out on something. You might not think through all these things that are sort of just good sort of policies and sort of make good deals.
Yeah.
Sure.
I think there's a question.
You talked a little bit about the responsibility for the board of directors and the management company, but you couldn't find really who ends up with the responsibility for doing this leasing act. I mean, sometimes this work goes on and nobody even knows that it's being done.
Well, look, that's a problem. If you find out that, it is a problem, and there's not really a perfect answer to it, but if you find out that somebody's doing work without having gotten the appropriate authorization, that you require, then that's the board's job, is to make sure that they do adhere to your rules. I mean, the board's job is not the day-to-day management of a building. The board's role is making sure that the bylaws and rules and regulations and co-op and proprietary lease, that they're enforced. So if you find out that somebody's doing a project, you got to kind of use your judgment. It depends. If they're they're changing a sconce or they're doing some painting, that might not be worth the fight. On the other hand, if they're, we had a situation once in one of our buildings where a person did a renovation and they installed a jacuzzi bathtub in their bathroom, and this was an older building, and for a variety of reasons, the water usage, the weight, they had a lot of concerns, and the board wasn't okay with it. The person just went ahead and did it, and the board got upset, and we litigated it, and we forced them to remove it. And you have to remove the tub. So it may require you, litigating, but if somebody's doing a project, and it's something that's significant enough, you may be able to require them to undo whatever it is that they've done.
It would be a good assumption if the board has a management company to deal with something, to deal with the building, that it would be their responsibility for doing this kind of leasing.
I think it starts with, the cornerstone of any building is you have a good superintendent, right?
Exactly.
So
Right.
you hope that if
It's a
someone's
team
doing
effort.
renovation, superintendent's going to notify management, and then that's how the board would get, word of that. That there was, that your management company would tell you that there's an illegal alteration in apartment 6K, and that, they contacted the owner of the land, and he stopped doing it until he submitted the appropriate documentation to know that everything is kosher.
Right. It's also going to depend on your, a couple things. One, what agreement, what kind of agreement you have with your management company. Do you want to pay your management company to be walking through the entire building every day and trying to make sure, every week or whatever it is, and trying to make sure that nobody did any projects or whatever? I mean, if it's a big project, I would think that the super, or whoever's there every day or regularly, will have some idea, like Stephen said, that something's going on. I also, I have some buildings where once a year or twice a year the board does inspections of the units. They, in this particular case, they want to make sure that nobody has any illegal washers and dryers and whatever, and make sure that the carpeting is appropriate. So once
The directors do that?
yeah, the board goes around. So they go around. They pair off, and they go in pairs, and over a couple of weeks or whatever, once a year, over a couple of weeks, they go and they inspect all the units. And so they would have an idea. In that case, if somebody did a project, over that past year, they would have an idea that they did it. So there's not one answer, for whose responsibility it is. It just depends on the situation. Getting back to Clementine's question earlier, we're a little out of order here, but
That's okay, we can be in, that's fine.
right. So what happens is when you do a project, if somebody does a project, right? One of the things for after the project's done, and that's part of this alteration agreement. the responsibilities of that unit owner or shareholder don't go away. They're still responsible. If they put in new equipment, you know, if they put in garbage disposal or a water filter or new wiring or, you know, whatever, or they change the shower or something, you know, put in a jacuzzi, they're now responsible for it. And they're responsible for the maintenance, for the repair, for any damage that it might cause, and depending on what the repair is, sometimes, and this is usually an alteration, and the board might want them to agree that when they move out, they have to restore it to the original condition before they move out, or you can have the new shareholder assume all the responsibilities that were their responsibilities under this alteration agreement. And that's usually an attachment to this contract, so they know the form. So, and that's another reason why you want the managing agent to be involved, why you want them to be aware that it goes on. They can keep it in their files, and then that way when the transfer is happening, either them or if they're not the transfer agent, they can alert the transfer agent. And that's what's co-op, it's condo, would just be, you know, when they're getting away with it. So they would know. So if the transfer is happening, they can make sure that this new purchaser has to sign off on the agreement when the purchase doesn't go through. And that way, or they have to restore it to whatever the condition was before the renovation. You know, that's kind of their options. They get the purchaser to sign it, and then the purchaser is now responsible for the maintenance and whatever, or it has to be restored. So, I mean, the rest of this, a lot of this we've kind of covered, and some of the not getting into with Jason. Well, we want to make sure the alteration agreement has indemnification of the harmless of the condominium. So if anything happens, it's not to say something that the condominium did, but if they did something that caused damage to somebody else's apartment or any of the common areas, they're holding the condominium harmless, and if somebody sues the condominium for that, this person's insurance now takes over. Okay, backwards.
I think one thing that we inherited a host of problems about as being board of directors and self-managed is that we're overlooking municipal, town, or village oversight and pulling work permits. And when we took over, we found that there were a host of work permits that had been pulled and had never been closed out. So now we make sure that we have enough deposit to cover the inspectors coming and absolutely closing out the permit, because it seemed to have been a trend that people did renovations, they would pay the permit up front just to get it by their co-op board, and once they had whatever they had one and done, which probably wasn't in compliance with the city, that they never closed those permits out.
Yeah, no, I agree with that. I mean, that's why you get the deposit up front, and that's one of the requirements at the end before, because they're agreeing here that they're going to get the certificates, they're going to pull the permits, they're going to get them closed out, whatever approvals they need, not just your approvals, but anything. They have to take care of it.
But I think it's important for boards or property managers to know exactly what your locality is going to require a work permit.
Well, that's what's good. If you have an architect or engineer for the building that works with the building regularly. Sometimes buildings will have different architects or engineers. Will have someone that deals with the facade, right? With someone who just deals with apartment alterations, who's local and knows the local building code, so they can make sure it's signed off. And they can say, this wasn't properly signed off. Even if their architect shows you some kind of seal or something from the town, there might be some kind of additional requirement that you're not aware of. So, depending on the scope of the alteration, it's significant. You really want to have your own design professional take a look at the end.
Yeah, and this is something also that's on, that's being paid for. It doesn't necessarily have to be somebody you have on retainer. If it's a big enough project, this is being paid for by the unit owner or shareholder. They're paying your architect or engineer's costs. So if you need that information, if you don't feel comfortable that you know what has to be done at the beginning and the end, and you want to talk to an architect, that's on their dime. Let's move on. And then you're basically completed. There was a question right up in front of you.
If somebody does the project, doesn't, and nobody knows about it, and doesn't have to start the project, what happens
When it's done? Well, they're responsible, but that's part of why you have a security. Well, you have a security deposit. No, I'm saying if you did this alteration agreement, you would have a security deposit.
But they did it without even telling them.
Right, then you have a problem. But then when they go to sell, you can do an inspection. Some places do inspections when people go to sell. The managing agent does an inspection. So if you do that and you see it, then you don't allow the sale to be processed until it's taken care of, or until the purchaser signs off that they're going to take care of it. You have somebody responsible. So if you're doing that kind of inspection, pre-sale inspection, you can, then you're able to take care of that situation. Again, I just want to mention, generally you don't want to allow them to touch building systems. You don't want to allow them to touch the boiler, your HVAC equipment, your plumbing, your door plumbing, your wiring. I mean, there's some stuff in the apartment they may have to touch, but you really want to be careful about letting shareholders touch any of that stuff. If a building system needs to be touched or needs to be shut off, if they're doing plumbing work, they may have to shut down the water for that line of performance. So, you need to be aware of that, and then you would want to have them pay your vendor, plumber, contractor, whoever, to take care of that. You don't want to let their contractor start touching your boiler or your plumbing system, whatever it is. And if it has to do with shutting down the water, that's something also you got to give the other shareholders that are going to be affected notice. You have to let them know that on Tuesday morning or whatever, the water's going to be shut off. You don't want that just to be a surprise.
Sure, so I'll just add a couple things that Jason's going to talk about insurance, just not with respect to in the alteration agreement, it typically says that if it's a co-op and there are additional fees owed by the shareholder that are beyond security deposits that they pay. In other words, let's say your engineering fees kind of ended up exceeding the amount of deposits, or in a condo, the same thing, the fees that were incurred by the owner or by your design professionals exceeded the amount you have on deposit. It says in the agreement that those are going to be considered additional maintenance or additional common charges, so that you would have a remedy against them after sort of the scope of the project to collect those fees. On the outline I prepared, basically list the provisions in the standard alteration agreement, just boil them down into succinct summaries. And also at the end of the outline on page 2, just I listed a few of the enforcement mechanisms on the book. As I said at the outset, that there is a specific provision in every proprietary lease I've seen that says an alteration is subject to the court's approval. So if someone violates that, they're in violation of the proprietary lease, and in theory, they can be evicted. And a condominium is a little more complicated because if someone's doing work, I'm sure all you condo board members know from experience that it can be very difficult to stop someone from doing behavior that's disruptive, whether it's making noise, smoking, or doing an alteration. It can be difficult to stop that behavior. You have to go get a court order, an injunction, which can be expensive and time-consuming. One remedy that is available to both co-ops and condos is fining. And the only caveat I'll throw out there is that it's sort of conflicting case law, whether a fine from coming out of the house rules is enforceable versus a fine that's authorized under your bylaws. It'd be better to have it under your bylaws, so that might be something you might want to consider amending, or that requires 2/3 owner approval, which is going to be very difficult to achieve. That's it. That's all. And then I think also that there'll be a whole insurance segment as well.
Any other questions for us before we turn it over to Jason? We're around if you think.
You all know Jason. He is co-president of Levitt-Fuirst Associates, insurance manager for our associations. He contributes to our monthly newspaper Impact. He's spoken at many of our membership meetings. definitely valuable asset. Jason Schiciano.
Well, I'm gonna try and do this in 5 minutes. I just got a thing on my phone. Donald Trump is contesting his own victory, so I want to get home and watch this play out. And Ed's gonna knock me off the stage if I don't get that quote. So here we go. I just wanted to give you a little bit more detail on the insurance ramifications relative to alteration work and the agreements surrounding that work and the potential outcomes if that paperwork is in good shape or not in good shape. So on your tables there's a handout with our logo on top. There were just a few scenarios that I thought I'd bring up, and I could come up with a million scenarios just like you could. You've probably experienced a number of them. A painter is hired to paint an interior of a unit. On his way to the building, the painter trips and falls on an unlevel concrete walkway, sustaining severe injuries. The painter files a lawsuit against the building and the managing agent, claiming that the building was negligent in failing to repair the walkway. The painter's monetary needs are fueled by the fact that his company does not have workers' compensation insurance to pay for his medical bills and lost wages related to his work-related injury. So there's a scenario. Who's going to pay that lawsuit? Who's going to pay for the legal bills in the settlement on the lawsuit? Co-op? Okay. Who should pay?
Insurance company.
Which insurance company?
The co-op.
Right. What could happen if you don't have the paperwork that Dan and Steve were talking about, if you don't have the identification agreement, if you don't have the additional insurance status with the contractor, the painter company that did the painting, if you don't have that stuff, the co-op's insurance is going to end up paying for that trip and fall lawsuit. And then what's going to happen? You're going to have a claim, legal fees, payout. Now you have loss runs showing that claim. Your insurance rates will be effective potentially for up to 5 years. That's what could happen. What should happen is that you have all the documentation that these guys talked about, and whose insurance ends up paying? The contractor's insurance. Okay. So a bathroom remodeler is hired to renovate. This is exactly word for word what you guys are talking about. Hired to renovate a 6th-floor apartment bathroom. The shareholder is out of town. After completing the plumbing work, contractor leaves for the day. He leaves, and the newly installed pipe joint fails, causing water damage to the walls, floors, and contents in the 6th-floor apartment and the apartments on the 5 floors below it. Whose insurance pays for that? That's property damage, right? The walls are floors are damaged, walls are damaged, and the contents in the apartments. Who's paying for that? Hopefully, right. If you have all the paperwork, if not, then the shareholder or unit owner's personal insurance is going to end up paying for the contents damage and the unit owner's improvements and betterments within the unit. And in fact, that might happen anyway, and then they would subrogate back to the contractor's insurance. And the co-op's insurance could end up paying for the damage to the common area. But obviously, you don't want that for the same reasons as the first scenario. So, third scenario, a police officer who does carpentry jobs on the side and without insurance is hired to renovate closets within the apartment. He drops some debris in the hallway. The shareholder slips and falls on the debris, causing injury. The shareholder sues the shareholder that hired the contractor, sues the contractor, sues the co-op board, and sues the managing agent. A whole bunch of parties. Everybody's named because that's what attorneys do, right? Same scenario here. If you have the risk transfer documentation, you have the additional insurance status for all of those parties from the contractor, if you have the identification, then his insurance is going to pay out. If not, all of those parties' insurance could be involved. So the goal here is to get the contractor's insurance to pay in each and every case to transfer the risk away from the shareholder, away from the unit owner, away from the condo co-op, away from the managing agent, away from the board, and onto the contractor. And the way you do that, as these guys explained, get the certificate of insurance, which should name all those entities as additional insured, preferably on a primary non-contributory basis. With waiver of subrogation, you can ask your insurance agent about that or your attorney. And most importantly, the indemnification agreement. I keep saying this, if you have the certificate only, and you don't have the written agreement, the certificate is literally worthless. You might as well throw it out because it doesn't mean anything without the written agreement signed by the contractor.
And for more complicated jobs, especially jobs involving, big projects, load-bearing walls, height-related work where people are on ladders or scaffolding within a unit, you might want to have your insurance broker review the insurance declaration pages for the liability policies of the contractor, because there are tons of exclusions beyond the ordinary normal exclusions that you normally see in a contractor policy. If that contractor has cheap insurance, basically you won't be covered without a review of that the contractor's insurance. You might be unaware, you think you're covered, but you're really not. Questions? How did I do that?
That was great.